and it is therefore a financial audit. Now, when we see the scheme under our statutes, a financial audit in this country can be done only by a chartered accountant. It can't be done by anybody else. So you may have, so I'm giving you an example. For example, take a post-mortem. A post-mortem can be done by certain people who are qualified and experienced with the requisite qualification. So as your Lordship correctly noticed in the observations, there are two requirements. First is qualification and second is experience. And what your Lordship correctly pointed out in terms of paragraph 40 of the division bench judgment, etc., was the latter, which is experience. You may have experience, but you may not have the qualification. If you do not have the qualification, in our understanding, it's fatal. Now, I'll tell you why. What is happening and what has been contemplated and what your Lordships have now held is that when there is a declaration that or a classification eventually by a bank that this falls under the caption of fraud, then there are huge civil consequences, and your Lordship correctly also observed there are criminal consequences which may also flow. Now, when you have enormous civil consequences and criminal consequences which flow, in our understanding of the law, that particular forensic audit which is required has to be done by a person who holds the requisite qualification. Now, the first question is why? The reason is that across the country and across several professions, it could be the law, it could be chartered accountancy, it could be medicine, we have self-regulating organizations. So if a person without qualification issues a wrong report or is negligent or condemns somebody because of the huge civil and criminal consequences that flow, he or she is subject to a disciplinary jurisdiction. Now, the first question I ask myself is that if you are not a qualified chartered accountant, you are not subject to anybody's disciplinary oversight, which is exactly the case here. So, sorry.
If the civil court, in the civil suit, if the High Court finds
yes,
that the report is untenable, one of the consequences bound to suffer is that the banks will have to remove him.
No, remove from what? Because there's nowhere to remove. There's no. I'm sorry.
Public sector banks that his services have been engaged and hired.
Yeah, but he must have a qualification. So if you, for a legal opinion, for example, you may be an expert, doctor, but you may not be allowed to give an opinion even on a basic issue in terms of law where a legal opinion is required. Sometimes you are required to have a legal opinion to support a particular position, or you require a medical certificate to support. There are so many statutes, my lords. So you, sorry, for example, yes, I'm sorry.
Today, when the suit is still pending and we are...
The suit is pending. Now the question is the interlocutory arrangement.
We are at the stage of injunction.
Yes.
At the stage of injunction, applying those well-known parameters.
Yes.
We have to see that prima facie whether this agency or this entity was qualified or not.
Qualified. So I'm on that. Qualified.
8.82 we have considered.
Please just take it up.
Yes.
Yeah, just have a look at 8.82 first. Yes. Please just have a look at that. Now just have a look at the title first, my lords. Yes. Bank as a sole lender, 8.8. Just see that. Please, it's on 101 on mine. It may be one page away. 101. So this is bank as a sole lender. Your lordship has that?
101.
A page, my lordship. First volume. Volume 1 itself. Most of it is here. Your lordship has 8.8. Your lordship had it a moment ago. Same, I'll stick to the same paper book. Your lordships have 8.8, bank as a sole lender. You have that caption towards the bottom. My lords, in page 101, paragraph 8.8. Bank as a sole lender. Now 8.8.2, which is at the top of page 102. So this first comes under the caption of bank as a sole lender. We are dealing with consortium, which comes later, but let me place 8.8.2. The bank may use external auditors. Now just see the context, my lords. We are concerned with financial accounts and we are concerned with a financial audit. So you may use an external auditor. Now an auditor is a very well-known concept, because it's statutorily recognized. When I show you the Chartered Accountants Act, amongst the duties and responsibilities of what work can be done by a chartered accountant who's a member of the institute, it is audit. So we are dealing with a financial audit. So a bank may use external auditors, including forensic experts. Now you may have an external auditor who is a tax expert. You may have a chartered accountant whose practice is only taxation. He may not be a forensic expert. So here you have an expression where the bank is a sole lender to use external auditors, including people who are forensic experts or an internal team of investigations before taking a final view on the RFA, which is a red flag account. At the end of the timeline, which cannot be more than 6 months, banks should either lift the red flag account status or classify the account as a fraud. Now, this is for single. We are concerned with 8.9. This is the applicable chapter for section for us. Lending under consortium or multiple banking arrangements. Your lordships have that. Now, in this, the relevant paragraph is perhaps 8.9.4, which is on the next page. Now, here, please go to about 6 or 7 lines from the top of para 8.9.4. Further, within 15 days of RFA fraud classification, the bank which has red flagged the account or detected the fraud would ask the consortium leader or the largest lender under the MBA to convene a meeting of the joint lenders forum to discuss the issue. The meeting of the joint lenders forum so requisitioned must be convened within 15 days of such a request being received. In case there's a broad agreement, the account should be classified as fraud. Else, based on the majority rule of agreement amongst banks, which at least 60% of the share of the total lending, the account should be red flagged by the bank and, now see the words, subjected to a forensic audit commissioned or initiated by the consortium leader or largest lender or under the MBA. Now the whole notion, now please take up the Chartered Accountants Act. Please just take up immediately the Chartered Accountants Act. Specifically, your lordships will just have a look at 2 or 3 sections here.
No, auditors might have been defined as a person with.
Yes, an audit can be done. Financial audit can only be done by a chartered accountant. There's no one else who can do it.
Our problem is that we are not agreeing with the way 8.82 is being interpreted.
No,
And
8
the
point,
moment we
Milords,
write something
may I just say this, Milords?
Yes.
When you use who can do a financial audit? Can a lawyer do a financial audit?
No,
As you
who
correctly
knows better
observe.
than banks?
Sorry?
Who knows better than banks that who can do the financial?
Sorry, Milords, yes, I'm sorry.
Clarification.
Yes.
Was there any divergence among the consortium members
Yeah.
with regard to the finding of
yes.
the individual?
No, there was not. That was another problem which occurred. That other problem was
We
that,
will come to that problem.
Yeah.
But the way you are reading
Yeah.
forensic audit
Yes.
in 8.9.4
Yeah.
is
Yeah.
should be read with the word classified as a fraud,
Yeah.
semicolon,
Yeah.
else based on the majority rule of agreement of at least 60.
Milords, may I just put it?
So there are two categories.
May I,
An
Milords?
individual bank of
Yeah.
a consortium,
Yeah.
red flags,
Yeah.
goes into 8.82.
Yeah.
This
No,
is,
Milords, you please go by that. I'm not saying
you
we
go by that.
yeah. You just go by that. Just note 2 things.
perfect.
Milords, just note 2 things. In serial number 75, just note 2 dates. The show cause notice is issued on 2nd December 2024.
Right.
And the report was furnished to me in January 2025.
Alternate.
In this case, your lordship may just note, and then we'll come back to it. Both insofar as the show cause notice is concerned, the report, the final order, of course, was passed after the impugned judgment. Keep that aside. It is subsequent to 15th of July 2024 in the case that I'm arguing. So I don't believe that the earlier report would have any bearing at all on the earlier master directions would have any bearing. Because everything in terms of the show cause notice, etc., has happened after 15 July 2024, when the language is absolutely clear. But I'm going to deal with your paragraph 8.8. I'm sorry.
If the investigation had started before that,
Yeah.
That can't be nullified only because that some new.
No, it's not a nullification, my lords. It's just a requirement.
Yes,
It's a common sense requirement. I think it's a common sense requirement.
Yes.
Experience plus qualification. Please, my lords, see, who can conduct?
In case of this
Sorry.
classification as fraud,
Yeah,
whatever natural justice principle, this court we have already laid down in Rajesh Agarwal.
yeah, yeah.
Beyond that, nothing can't be.
My lords, it's not natural. I think your lordship is right.
More than that.
My lords, your lordship is right.
0.82 where you are really arguing.
Yes, yes, yes.
Because our difficulty is that today if we define this expression,
Yeah,
then it directly impact the suit.
yeah,
Otherwise, including or an internal team for investigators.
yes,
Now, or qualifies, or gives a complete alternate.
yeah.
So if the mandate was only to her chartered accountant, why you would have used the word or internal team
Yes.
for investigators?
Yeah, but by the very nature, Manoj, the suggestion is, I put it a little differently. Let's just step aside. I ask myself, there are, as your lordships have seen, not just domestically, but there are internationally situations which arise where you may have funds, etc., which are flowing. And you have law firms actually which specialize in this particular area, where you have lawyers. Now, I ask myself a question. Supposing this particular lawyer is in the business or is in the professional field of tracing funds which may be going, can he, along with 3 or 4 others similarly, create a firm and then say that I am a forensic expert for forensic audit, because he has to be he continues to be under the discipline of the Bar Council of India. And therefore, insofar as lawyering is concerned, yes, he would be accountable.
Unfortunately,
The
this is
question
your
is,
case
sorry.
also.
Sorry?
Unfortunately, this is not your case also, that the person is incapable.
No, I am saying he doesn't have the
Or he
qualification.
does not know anything. You are also only on the point of chartered accountant.
Qualification.
Or the contents are wrong.
You see, there are two
What
elements.
records,
One
contents
is-
are not disputed.
One is that as far as
The
chartered
findings are
accountants
not
know-
under challenge.
One is that as far as the your lordships have the Chartered Accountants Act. So let me just summarize it and then I'll come to it. The Chartered Accountant recognizes 2 situations. One, an individual practitioner, and the other is a firm of Chartered Accountants. Both are qualified to do the work, which is contemplated, which is, I think, fairly obvious. And your lordships will have that in subsection 2 of section 2. So just see, so Chartered Accountant means a member who is a member of the institute. The institute, your lordship knows, is defined over there as the Institute of Chartered Accountants in 2E.
Yes.
Now look at 2 subsection 2. A member of the institute shall be deemed to be in practice when individually or in partnership with chartered accountants in practice or in partnership with members or other recognized professions as may be prescribed, he in consideration of remuneration received or to be received. Now please see Roman 2. Offers to perform or perform services involving the auditing or verification of financial transactions, books of account or records, or the preparation, verification and certification of financial accounting and related statements, or holds himself out to the public as an accountant. Now, to be in practice, because this is an exclusive license.
When mandatory qualification is to be prescribed,
Yes,
8.82 would have
Yes.
very conveniently said
yes.
that no person shall be included in the team of
Yes.
so and so unless he is qualified chartered
Now,
accountant under this
you're right. So now that I would say your lordship is correct to take that view prima facie. However, your lordships will see that now in light of page 203, which comes into force on 15 July 24. So it's coming into force in 15 July 2024. Please go to 203. It's beyond the pale. It's completely beyond the pale. Just look at 4.1.
Yeah.
In case of a credit facility or a loan account classified as red flagged account, banks shall use an external audit. And there's a footnote. Auditors who are qualified to conduct audit under the relevant statutes. What can be clearer than this? This is not legislation in the sense of a parliamentary statute or a state legislature statute. But this has been held by your lordships as a 35A direction, which has a statutory flavor. Now, once the Reserve Bank of India, way back in July 2024, specifies that the auditors who are qualified to conduct an audit, whatever might have been the efficacy, so they realize that the experience is very good, but experience by itself is not enough. And Manoj, I would like your lordships to just consider this facet. Just consider this facet. of, Millards, please see, if you look at the huge consequences which occur, civil as well as criminal, Millards, the question I ask myself is that shouldn't the professional who issues such a report on the basis of which the bank acts be subject to some disciplinary proceedings, some accountability, apart from, Millards, some filing a suit? So my respectful submission is that that a reasonable way, which is what the single judge did. Eventually, he may be right, he may be wrong. That's a separate issue.
Public sector nationalized banks have engaged these services. It's not that.
No, Millards, I think your lordship is
brought
correct.
in there and.
Your lordship is correct in that observation that the banks which have engaged the, yes, I'm sorry.
Diwan, for us, will be substituting the wisdom of the banks. It is they who know the best, who can be the best person to go into all these accounts.
No,
it is their money. It is their money which, according to them, has been siphoned, defrauded, sent.
No, that they went through. You're right. So what happened here? As Mr. Sibal also indicated to the court, was that the company was in CIRP. So therefore, your lordship knows that the RP is the person. Now, this particular report, which is the forensic audit report, Millards, by BDO LLP, that itself records that the person they interacted with was the RP. Because why? Because the RP, now your lordships have said, RP has no adjudicatory authority. He is merely a pro tem administrator who has to look after and pass on the baby upon CIRP reaching conclusion. It's not as if he has some, because he's just a professional, my lords, under IBBI, etc., who's holding fort until the process is completed.
That may be a second ground. You see,
No, I am just saying what has happened here.
That may be a ground where probably you want to say that since you were not in a way kind of card or given a.
He was involved in the process.
On interim relief.
He was involved in the process. A personal hearing was given. We have not come to that, my lord. He is only on the signature part. The signatory is not a member of chartered accountants.
No. So there's two things. First, this is not a chartered accountancy firm. They have said so on affidavit that it's a consulting firm. So please note this. So forensic consultant is one thing. I accept that. They may have a rich experience, but that in itself does not meet the requirement of qualification. I would urge your lordships, my lords, when you have such enormous, I think the factor which the Chief Justice has put to be is, I think, a very important factor. Namely, that there is a certain judgment and a wisdom insofar as the banks are concerned. I have no doubt about that. But equally, there will have to be, or there ought to be, a balancing because of the enormous civil and civil consequences and criminal consequences. So we are urging the court that taking a balanced view, qualification should be read in.
Knowing the background of this agency as reflected in para 40 of this.
Yes.
Can't be said that somebody has been handpicked only to secure a report against you.
No, I'm not saying that.
Difficult to hold.
No, Millards, no. So there are two elements there. Millards, that's a separate. I accept that.
They were selected by tender. The BDO was selected by tender process by the consortium unanimously.
Millards, the question before the court is that when in July 2014, there is now, I think your lordship's point is correct. Namely that, look, this report, as your lordship recalls, is of some vintage. It's of 15th October 2020. Now, that's the report. Now, in 15th October 2020 report, and you're issuing a show cause notice, in my case, your lordship may note, was on 2nd of December 2024, which is post 1st July 2024. So, at least at that point of time, when you're issuing the show cause notice, I think qualification becomes important. So, may I just say this?
But we are probably, definitely won't like to say anything. An inquiry, an investigation which had already started.
Yes.
The investigation was complete even before 2024.
Yeah, but ultimately, eventually, if there's a show cause notice which your lordships have held, there may not be a requirement for a hearing. Sorry.
Applying the principle, assuming that 8.82 deserves the interpretation.
May I make a suggestion? I think the way your lordship is reading 8.82, I mean, it's not for me to say, it's not a possible interpretation. There's a possible interpretation by the division bench, there's a possible interpretation by the single judge. There are two possible interpretations. Now, if it were just 8.8.2, I think we would not have so much to say. Possible interpretation, no more. Now that we have the advantage of a subsequent RBI issued July 2024 statutory direction, which says qualification of an auditor in footnote 14, which your lordships have seen, this buttresses the suggestion which we are making that it was always intended to be someone who is qualified in the law, not just experienced, qualified in audit, financial audit, my lords. There may be other situations. But these are safeguards. These are safeguards which are there. There are huge consequences which flow. Your lordships may consider some balance, my lords.
No.
So I agree that.
Since you are entirely depending upon a circular of RBI, maybe that, I mean, somebody may suggest you to amend the suit and implement RBI also as a party dependent. Let them also come and say that there is a circular or a mandatory instruction.
Eventually, my lords, it will be on the basis of interpretation of that particular clause which will come in, which one applies, etc. That is to be done at the final hearing stage. But at this juncture,
when there is a possibility of two possible views,
I believe so, my lord. I mean, I don't have.
Because of the vagueness,
Yeah.
then best is that the author of that circular, because it's not a statute that
So it's possible that.
Parliament is not expecting, nobody will ask Parliament
I know.
to explain that why you are.
Correct. But your lordships have said and held repeatedly that look, it's the author of a particular interpretation. Stepping into the box is not determinative. We, the courts, will eventually decide what it actually says, one thing or the other, having regard to the language used. Of course, context may be important.
That platform is still alive for you because your suit is pending.
Yes.
Final view will be what the learned single judge.
Yeah.
If the suit is before a single judge.
Yeah.
Final view will be that what the single judge holds about 8 points. Ultimately, in detail, this interpretation will take place.
But the question will be.
That you succeed at that time.
But that time, your lordship knows, as was mentioned, banking is, if you suck out the oxygen from a company in terms of not making finances available or banking facilities available, that's a death knell. So the expression used was it's civil death insofar as companies are concerned. So ahead of civil death, we were suggesting that there ought to be some balance. The single judge has also passed a balanced order. As your lordship says, the operative directions, the operative directions of the single judge also are that having regard to this qualification requirement and
that was very, very highly technical view that I think division bench.
But this will be technical, my lords, in the sense that if we are talking about civil death of a company and withdrawal of banking facilities on the civil side, as Mr. Sibal said, my lords, as far as criminal investigations are concerned, nobody is immediately asking for a stay with regard to that.
Neither we are directing nor we are stopping. We are not on that issue because that is beyond these pleading these proceedings. But whatever remedy you may avail there. Can't really say.
Lord, I am appearing in the third item, Lord, item
Yes,
74. Just 2 minutes, Lord, for me, Lord.
For the same person?
For IDBI.
For IDBI bank?
Against IDBI.
I'm in a SLP of IDBI.
Same petitioner, plain petitioner.
And I appear for IDBI.
In that matter, I. Lord, taking cue from my two learned senior colleagues, I want to invite most kind attention that the word auditor was envisaged and conceived way back in the Banking Regulation Act of 1949. That Banking Regulation Act of 1949, section 30. Lord, I'm just reading this 2 line. This is section 30 of the Banking Regulation Act 1949.
Yes.
It says, and Lord, this is applicable to all banks. It says the balance sheet and profit and loss account prepared in accordance with section 29 shall be audited by a person duly qualified under any law for the time being in force to be an auditor of a company. Now, my lord, a person who is qualified to be an auditor can only audit the balance sheet of these companies. This, because the auditor has to be a qualified person in accordance with law, that was envisaged way back in 1949. And Lord, that is why the circular of 2016, Lord, the first sentence is external auditor. Of course, Lord, it further goes on to show that even the internal team. But here is a case they do not say that we have conducted an internal investigation. They say we have appointed an external auditor. So if they have appointed an external auditor, not an internal team, then my lord, that external auditor has to be qualified in accordance with the statute. This is point 1. Point 2, my lord, in my case, I have placed my appointment letter of this auditor my lord, the bank, while appointing the auditor, my lord, may kindly see if my lord has allow me to read page 200, just one line from the appointment of this BOD. In my case, my lord, IDBI case, it says while making him appointed, this appointment was being made. It says you will function in such a manner that it will not cause any business loss to the bank or entail any legal or other responsibility / liability to the bank or its officials. This is a mandate being given to BDO. Now, my lord, while making this appointment, further at page 201, the period which is covered for this audit is being given. Now, the period here, it says, my lord, this is clause 13. The period to be covered is last 4 years. Now, my lord, last 4 years, it was appointment is in 19. Last 4 year goes back to 15. When this report is seen, the report says I have started auditing since 2013. It is beyond the point of reference. Now, my lord, it goes on its own from 15 to 13. Lord, admittedly, at the stage of this forensic audit by a person who is not qualified auditor, there was absolutely no notice was issued to me. This is a fact. But the other side has been saying, no, they were heard. No. Now, what happens is, my lord, this report for me is meaningless so long as it forms the basis of a shock cause notice issued to me. My lord, in my case, the shock cause notice issued to me was in May 2014. The shock cause notice is on record, Annexure P7. Lord, I'll read the document if my lord wanted. The document says there are allegations of siphoning of this, you reply. I write a letter to them that please disclose the basis on which you are issuing me the shock cause notice. In response to my letter for the first time, in January 2025, they say the reliance we are playing on these facts on a BDO report of 2020. This is for the first time they say this BDO report is being relied upon to issue you a show cause notice. Now, my lord, for the first time, because Lord, this audit report, I am not a party, I was not called upon, I was not consulted when this auditor was appointed. I had no concern with this. But it is only when in 2025, for the first time, the bank says the basis of my show cause notice to you is this BDO report. And now you reply. Lord, it is at that stage, I filed a suit saying all this, he's not qualified, this BDO report. And Lord, one more important aspect I want to flag. BDO report itself says, the relevant part has been read by my learned senior colleague, Mr. Sibal, that this is no audit report. And please don't use it as an audit report. There is no finding of a fraud. So when this BDO is appointed, there is a caveat by the bank saying, please conduct in a manner that bank is not in a dock. This is the kind of independent auditor they appoint with this mandate. Appointment is for 4 years, up to 19 to 15. He goes back to 13. When he submits the report, he says, please don't treat it as an auditor's report. Now, this auditor's report was gathering dust, if I can say this, from 2020 to 25. It comes to me only in 25 when it forms basis of a show cause notice issued to me after the red flag account, Lord, before they take this. And now I got a stay.
Must be, your influence must be working on them.
I'm coming.
They are taking no action despite the report
Now,
being
Lord,
there.
just one, I'm so grateful, Lord. Just one thing to add. Now, Lord, because stay was granted at a stage of show cause notice, we got a stay. They were in appeal. After the appeal is dismissed, immediately thereafter, the orders have been passed declaring the account to be a fraudulent account. And we had no opportunity to go anywhere. Absolutely no opportunity. Lord, in case, if there was to be, Lord, may consider two aspects. This is my humble submission. Now, after the DB dismisses, allows their appeal, vacates the stay, if they are wanting to pass an order, they should give me at least a show cause notice that now the stay is
They were
over.
heard,
It's
personally heard.
It's, my lord, if they
Reply
can
has
make a
been filed.
statement, they were personally heard after the division bench judgment. I have no case, I'll not press it. My lord, I had a stay. During that stay, of course, there is no hearing. They could not have passed an impugned order. When the stay was vacated,
There is no impugned.
they immediately passed this impugned order. Let them say that after the DB vacated the stay order, I was given an opportunity of hearing, my lord, I have nothing to say.
All right, all right. Right on.
Now, my lord, consider, my lord, a remand if I can say this.
Since you've been directed against. 23rd February 2026. Against the judgment dated 23rd February 2026 passed by a division bench of the Mumbai High Court. In appeals number 430 22 4305 22 of 25, 43052 of 2025, 430454 of 2025. पहले उसको 43024 भी था 24, then 43052 and 43054 and comma 43083 43081 and 43083 of 2025. We have heard Sir Principal Shyam Diwan and Mr. Gar and senior counsel representing the petitions, as well as Mr. Prashad Mehta and solicitor representing you are representing the consortium bank.
List one.
Huh?
We give the list, my lord.
Senior counsel. We see no ground to interfere with the judgment of the
Wait.
High Court. In terms whereof the order passed by Lansing judge granting injunction in favor of the petitioner has been set aside. So, since it is all clarified that the observation made by the division bench shall have no bearing on the merits of the suit, which is still pending. The petitioner shall be at liberty to pursue the suit in accordance with law. Subject to the cooperation that may be extended by the parties, the High Court is requested to expedite the disposal of the civil suit. Next paragraph. Similarly, if the petitioner has any other remedy available in law, he shall be at liberty to avail such remedy in accordance with.
Well, just one further request, Mullah. I would like to sit with the banks and settle the matter. Mullah, will your lordships give me that liberty?
There is no.
One second.
Taken away that liberty.
I'm
That between you and the banks.
no, Mullah, your lordships may will record that I would wish to sit with the banks and settle. Just my statement, Mullah. Let them not agree. I don't mind, Mullah.
My lord, your lordships may not say it would be used.
No, we are recording their statement.
My statement.
If he wants to sit, he can sit. But he doesn't.
That's all I'm
tell
saying.
your
That's all
lordship.
I'm saying.
Kindly do not say, I know
Why
the reason.
why should he?
I know, my lord, what are the repercussions.
No, what repercussions? And I am
Asked
asked.
to not do that, your lordships will be doing something.
Banks, you write to the banks that you want.
Yes, if he.
We have written, Mullah. We are waiting for an order. This order. We have written to the banks. We would like to, Mullah. After all, they have settled with so many others.
Lord, I know, my lord, where it would lead to. Therefore,
What
I'm
will it lead
requesting
to?
the lordships.
We have seen
I
you
would urge your lordships not to.
Mullah, they have settled with so many accounts, Mullah, with people sitting abroad, they have settled.
Yeah, record our statement.
Record our statement, Mullah, nothing more. You may not consider it.
Oh, there is no.
All right.
Supreme-
Well, you should. This is not fair, Mullah. Not fair.
Anything argued against Mr. Sibal is always not fair.
Available. You
Well,
are-
it's not a remedy, Mullah. We want to settle.
No, that's- I know where it would
Mullah,
go.
no,
I don't
no.
want to
You
say
may
it.
say no. You may say no. This is my statement,
Beginning
Mullah.
of a new inning, my lord, please do not.
You say
If they want to.
council
nobody prevents
states
them.
that he wishes to settle the matter. You may say no to that. I am only making a statement that should be recorded. Why should you object to that? It's my
These
statement.
are not the proceedings, my lord.
No, not proceedings, it's my statement.
Statement. I know exactly where it's going.
Whatever. It should, I mean, it should not be that you should be a stumbling block in the settlement.
It has to be.
It has for 5,000, 8,000, you could settle it.
Your lordships have said all remedies are open.
No, no,
I
remedy
know where
is a legal
exactly it's
remedy.
going. I know
I'm
where
saying
exactly-
my statement be recorded that I wish to settle. I wish
Forum
to
be
settle.
not used for something other than
No, no,
what
no,
we are
nothing.
unable to conceive.
I am saying I wish to settle. You may say, no, I don't want to settle. But how can you say I can't record my statement? It's a lender-borrower issue. I'm willing to
Get the
settle.
statement recorded for that.
That's right, only for that.
No, you don't need to get it recorded for
So
that.
why should you object to that?
No, no, I know where it's going.
Why should you
There are
object
other
to that?
proceedings going on. There are criminal proceedings going on.
This
cyber
only
cases
show-
being-
this-
And, my lord, I
should
know, my lord, why this.
I mean,
statement-
normally
The
the
lordship's
solicitor would
order
never
has
oppose
its own
this.
Sanctity.
Why would the solicitor oppose an
Its own sanctity.
innocuous statement or like this? It's my prayer I want to settle. I wish to settle.
Say that as regard to his statement, we don't express any opinion.
Yes, your lordship may say that. Your lordship may say
Statement
that.
recorded in your lordship's judgment will have its own sanctity.
It will not.
Before
because you are
other
not willing
courts,
to settle.
other proceeding, which your lordships are
No,
not.
no,
aware.
no, no, no.
I
How
know
can it
exactly
be?
where it's going.
Well, how can it
Therefore,
be?
please
How
leave it
can-
at that.
How can it be?
But the idea is to facilitate a conclusion.
Why
I know where it's
somewhere else?
going, my lord.
Mullah, I can't understand how my learned friend is objecting to a statement being
Yes,
made by
yes,
me
because
that I
know-
wish to
I
settle.
can conceive what is
Your
going to
lordship
happen.
will say, Mr.
I
Sibal wishes to settle the matter. It is for the banks to decide.
Can say like this, as a well, statement that he wants to settle, that he would approach the bank for settlement. We do not express any opinion.
Deeply obliged.
Please, sir.
Thank you for the patient hearing.
Okay. Thank you, Vishal. May I- In item number 7, I'm appealing for the petitioner, your lordship. My humble submission would be, your lordship, the petition.
Please, how we, every day people want us to now regulate the High Court.
Difficulty with me is this, your lordship. The respondent number,
See the predicament, how every day if you start passing order, that High Court will take up only those cases where Supreme Court is passing.
the difficulty with me is this, your lordship. The respondent number 4, 5, and 6 are enjoying the privileges conferred by the respondent number 2. The tender was floated. How many submit, your lordship?
We are unnecessarily
Entertaining this petition,
Now the difficulty with me would be, your lordship.
we grant liberty to the petitions to approach the High Court with an appropriate application and make out a case for out of turn hearing.
Difficulty with me is this, your lordship. So many.
Once we will attach this order, it will.
Difficulty with me is this, your lordship. I these twice or thrice mentioned before the learned in the division bench. They actually taken the matter, but the matter could not be reached. The difficulty with me is this, your lordship.
You are right. Actual problem is that High Court, the pendency is enormous. And it's not that we may criticize sometimes judges, but whatever feedback I'm getting, there are judges who are dealing with 150, 200 cases in a day. And many of them are really working as very dedicated team, but still the turn does not come.
It is entirely different, your lordship. There is a time bound manner because this project has to be completed.
That's why we have said, please apply you attach this order, our order along with the application, you find it.
Some time may be given, 2 or 3 months, whatever lordship deems appropriate.
May not be appropriate for us.
My matter will not be reached, and by the time they will say that the work is over, we have received
You-
the money.
So now we file an application.
Petition in the matter is much of the
File application, you will,
It may kindly be ordered in the order that my matter may kindly be.
no, we cannot, that will not be appropriate for us to direct the High Court to.
I'm just making a.
Take any matter. We have said that you may apply, the petition may apply to the High Court for early hearing, and make out a case that the matter requires out of turn hearing due to essence of the defense. Item 48.
Lords, 48 are 8 women, my lords, advocates from Uttarakhand. In respect of your lordship's directions.
Only we have passed several orders. There is a committee constituted. Are the petition not aware of this thing?
We represented to the committee, my lords. We have not received any order from the committee. Your lordships on 13th April, in respect of Telangana, in fact, notes have made an order. Court officer. Please pass it on, please. Your lordships have, my lords, recorded in the order the directions issued by the high-powered committee, my lords, on 9/2/2026. Now, as per those directions, also clause D, a certain elimination process had to be followed in respect of the women candidates. Now, if that was to be read with, my lords, the rules applicable in Uttarakhand, there is a single transferable vote prescribed. None of that has been adhered in this case, my lords. As a result of which, my lords, the women,
Approach the, if the petitioners.
we have already approached, my lords.
It is stated at the outset that the petitioners have already approached the high-powered election supervisory committee headed by Justice Sudhanshu Dhulia, a former judge of this court. If that is so, we dispose of this petition with a request to the committee, to the above stated committee, to
Would you like
take up the
further representation?
petitioner's representation come appeal
Like to file a further representation.
and pass appropriate orders. And pass appropriate orders.
Lords, a further representation, if required, may also be permitted because
We have liberty to supplement their representation. And for that purpose, they are permitted to submit a copy of the writ petition as their supplementary representation. Because you put up the entire writ petition itself.
please, lords. I'm so grateful. So grateful to your lordships.
My lord, there is a small weir which is being built for water extraction in a river which is deep inside Kerala. Now, my lord, here there is the NGT, my lord, has purported to exercise jurisdiction in respect of that suo motu. Now, my lord, both the Constitution and, my lord, the Interstate Water Disputes Act bars the jurisdiction of all courts, including, my lord, the Supreme Court as well. And your lordships have actually recognized that and dismissed Article 32 petitions. My lord, just have a look at the section.
Meanwhile, further proceeding, meanwhile, further proceeding before NGT. NGT, Chennai Banks in bracket South Zone in OA number 181, stroke 2024 shall remain still.
Lordship, deeply obliged.
Lord, the present petition is seeking representation of women advocates.
So then don't file a petition, please. Don't embarrass us and don't create complications for yourself. What will happen if you dismiss it?
Lord, actually, so far as government panels are concerned, if they can.
Now that we are granting something, so slowly we are achieving. These things don't happen in a day. Look at the, after all, how much journey we have already successfully crossed. You should people, the issues of this requires consideration more on administrative side by different stakeholders. It is neither expedient nor desirable to entertain or to take up such type of issues on judicial side, unless the peculiar facts and circumstances warrant such intervention. Consequently, the petition disposed of with liberty to the petitioners to submit comprehensive representations to all the stakeholders.
This is, my lords, that faceless assessment batch. The same order may be.
All right. Disposed to be disposed of in there.
In terms of that.
Three or four aspects. An order comes to be passed, an inquiry is conducted, there is the gentleman who had recused gives a letter which is never provided to me, never granted any inspection. In the entire inquiry, there is nothing else done. There is an altercation with my father. My father has two sons who are judicial officers. The order by itself does not even name me. And in that context, my lord, the disciplinary authority has also not, the full court of the Honorable High Court has also not interacted with me, no hearing granted to me at all. And all these aspects, my lord, with utmost respect, the impugned order doesn't deal with any of them. Specific pleadings taken in my writ petition that this document was not provided, not given to me. Please have that, not straight away. Could your lordship just have first?
What is exam? Itself.
Not in my presence. I bow down. I bow down. I am a judicial officer posted somewhere else. And my name is not recorded in that order. What is said is that the council has a son who approached. He has two sons who are judicial officers. That's a matter of fact.
Then your brother should have come and said, I approached.
Because that was, in fact, my case was that I never approached. The
Instead of mistaken identity.
No, may I say this?
And you say, I did not know the district judge. So the High Court infers that there cannot be any enmity.
Can I show the finding, my lords, after the inquiry? Please just have that. The finding itself says it is not fully.
One better than High Court, which really militates against you is not findings. Is the judicial order which has a presumption of correctly recording.
I bow down. In the context of judicial proceedings between those parties, I am not a person who's there. Could your lordship just have page 81, my lords? Please have 81. The finding recorded in the report after the charges, I'll read that. It is established.
Who knows better than High Court that who is the person out of the two brothers who made it and who did not make it? Do you think the High Courts are not aware of these things?
Can I request your lordship? Please look at the finding that is recorded. That's all I'm saying. Please forget everything else. Whether document is given to me, not given to me, all of those aspects aside. Let us find out what is the highest against me. Please have page 80. Would the lordship just do the luxury of looking at this one paragraph? The finding is, last line, it is established that it was the delinquent officer who approached the presiding officer with reference to the two review petitions, out of which one was case bearing so and so. But whether in the said meeting of the delinquent officer with the presiding officer, he has made an attempt to influence the presiding officer by seeking his favor, which has resulted in the interference of administration of justice and judicial proceeding, thereby he failed to maintain so and so, as detailed, is not fully proved. If it is not proven, the fact that I have met somebody by itself, and that is the reason why the recusing officer is not examined, there is not a single document placed to me. There is no concept of cross-examination, let alone asking a question. And the point that is made to me is the fact that a judicial order is passed by him in a inter-parties proceedings. I am not a person there, and my instructions are that even that order has been taken up in revision by those parties, and there's a stay operational.
Have you retired or you are still in service?
I'm still in service.
Better.
Even the finding, my lords, is that there is no finding of any approach.
The High Court on administrative side has examined, the High Court on judicial side has examined. They have pure question of fact. And there is no question of law involved.
The inquiry report itself was not given the.
Case not given.
I'm obliged.
But if 53 can be taken up on 24th, subject to a lordship's convenience. My learned friend has agreed, Manoj.
I think they may not change the nature of the land. They say they have taken possession.
They can't possess it, dispossess.
Kindly have it on Monday. Kindly have it on Monday. Kindly have it on.
Whenever your lordship may keep it, I have no mind, my lord. But my friend is there, so therefore I will take it.
Not Monday.
Monday.
Not Monday. We'll give a short date.
Only, my lord, I only pray, my lord, that they
Yeah,
should not
they
change
cannot-
the nature because they want to hand it over to somebody else.
Lord, I'm appearing for the petitioner as well. There cannot be a disposition
Mr. Venugopal is not
because
reading.
my learned friend asked for time. And therefore, my lord, let the
No,
status
my lord,
quo-
then I'm ready. I didn't know, my lord, that they are seeking some interim order. my lord.
No,
No,
only
let the
It can be heard. I have
my
no difficulty.
friend should make a statement that they.
No, I'm not making any statement.
the status quo is to continue by taking adjournment, my lords. They can't dispose.
I'm not taking adjournment.
All I'm saying.
AG Sahab, I'm not taking adjournment.
Status quo was continued by the High Court, my lord, so therefore. है ना यहाँ पर नीचे.
Long back, my lord, it's a,
Lease
and
period,
even 99 years are over.
even if the lease was
Lord,
not
sir,
happening,
if he wants to argue, let us argue. My lords, my learned friend, I think, wants the matter to be argued now. I leave it to your lordships.
Mr. Venugopal, if you want to argue, we can hear the matter. There is
Yes.
no difficulty.
Yes. Very well, my lords. My lords, this is a case of two salt pans being leased for 9. Two salt pans being leased, my lords, for 99 years. The leases would expire in 2016. But 12 years before the leases would expire, the government, my lords, cancel the leases on the ground that there has been violation. Naturally, my lords, we filed a civil suit challenging, my lords, the cancellation. And that, my lords, was pending before, my lords, the City Civil Court, my lords, Bombay. At that time, my lords, when the matter was pending, the entirety of the lease was about to expire, when, my lord, a very strange application was filed. A notice of motion was taken out by the Union of India, saying that the whole of this is expired and therefore it's infructuous. But, my lord, said, I need not, my lord, point out that if, my lord, the challenge to the cancellation 12 years before the expiry is upheld, it could be, my lord, dismissed, it could be upheld. If it is upheld, then, my lord, so far as the expiry is concerned, it would not, my lords, make any difference because I have a renewal clause, which I'll read to your lordships presently, which seems to be a matter of right, provided I have not violated the conditions. And therefore, my lord, so far as those circumstances are concerned, it is, my lords, the termination which has to be dealt with first. And if the termination, my lords, is held to be bad, then, my lord, my right of renewal is a right itself, not a mere right to seek renewal, but a right which I'll read, my lords, to their lordships. The notice of motion, my lord, was dismissed. Notice of motion having been dismissed by the City Civil Court, one would have expected, my lords, that the issues which are framed in the suit would be decided first, which clear each one of the issues related to the validity of the termination. But instead of, my lords, going into that, they preferred an appeal, a revision under 115, where, my lords, they sought, my lord, an interlocutory application by interim order, and notice was issued on that. We filed, my lords, a reply only to the interim order, the continuation of delay of 200 days. On that, my lords, instead of dealing, they condone the delay, and, my lords, subsequently take up the matter for final disposal without even calling for the records, because the delay was excused. And then, my lord, the result of all this is that the notice of motion dealt only with the expiration of the lease in 2016. But the termination of 2004, 12 years earlier, was, my lords, a matter to be decided first. If I succeeded there in the City Civil Court, then, my lord, the result is that my right of renewal should be taken up and by the government. Now, I had, my lord, brought to the notice of the court and filed an application for renewal, and therefore that would have to be decided. Now, please, my lords, see the judgment at page 6.
Mr. Venugopal,
Yes.
the lease was terminated according to you. Lease was terminated in 2005.
2004.
On
12 years before the expiry.
2nd November 2004.
Yes.
You filed the civil suit in 2005.
Yes.
Hmm?
Challenging it.
First of all, we do not know what happened. These two suits filed in 2005 and injunction is being granted only in 2016. Once,
Status quo order granted earlier only.
Ole.
The suit was filed.
Ole.
That is
The
very much
point
clear.
is that in 2016 you were aware that your now 99-year lease period has expired.
But meanwhile, my lords, the application for renewal has been filed, provided, my lords, the city civil court's decision is there. The question is, which is the issue to be decided first?
Issue is the prayers in the suit had not been amended till 2025. And the issues framed also become academic because it only speaks of the breach being invalid and the lease being subsisting during the tenure of the lease. There is no mandatory order for grant of extension or renewal of the lease.
My lords, may I put your lordships? What is the issue? Suppose the city civil court decides a question of termination in my favor. The fact that it has been delayed makes no difference. The issue is related only to termination.
Sir, amendment of the plaint and asking for a new relief of renewal request to be made.
I am not asking for renewal now.
Of the suit itself. If the suit was filed, as you rightly say that this is what was in Shipping Corporation of India relied by the trial judge, that there was a prayer for amendment of the plaint and the prayers in the suit was for the renewal of the lease. In this case, the High Court distinguished Shipping Corporation by saying that the scope and ambit of the suit was only in respect of the lease and there was no amendment prayer made. It was only made at the time when the revision petition was being heard in 2025.
The lease was to expire in October 2016. Application for renewal was made, my lord, in February 2016, 8 months before the expiry of the lease. And that, my lord, was required only to be made 6 months before. Therefore, I had applied for the renewal of the lease in accordance with, my lord, the lease deed. Now, please look at this judgment. The city civil court, my lord, suit was pending.
You would agree that when you made the prayer for renewal, as you say, it was an automatic renewal subject to your seeking such renewal, and you made that renewal, it amounted to a subsequent cause of action. And that subsequent cause of action fructified in 2016 upon the lease terminating by a flux of time. Now, from 2016 till 2025, you do not seek an amendment for the relief arising from that subsequent cause of action, and you claim it only in 2025, and that is why the suit has been dismissed.
Lords, with great respect to your lordships, lords, let me assume that I had not asked for amendment.
Yes.
I had only asked for renewal of the lease in accordance with the terms of the lease, which is 6 months earlier to the expiry. I had asked 8 months earlier. I have not asked for amendment. Assume so. In which case, my lords, here is a city civil court suit which was pending, where the issue was a termination of 2004 valid or not valid? If, my lords, the termination was invalid, then, my lords, alone would the right of renewal accrue to me. Just to be on the safer side, I had made an application saying that please renew in accordance with the terms of the lease. Now, please see, my lords, the judgment. At page 6, I specifically argue.
You are not expected to wait for the outcome of the suit and have a finding. You could claim as far as you are concerned, you could raise your claim for renewal of the lease.
My lords, it is only if the
Public property can be
the
given
right
like
of,
this on
my lords,
throwaway price.
the right of renewal would
I'm sorry
arise.
for the interruption. We have made specific amendments that central government in 2013 has come out with a policy that henceforth lease will not be extended without auction. There would be an auction.
Public
It would
property
be
has
only
to
for
be
20 years.
Nowhere on
The
record.
best,
This is on record.
highest bidder will get it. That is page 330 of the paper book.
That's not
Page
communicated to
330.
me. We don't know about it.
No, it's a part of our pleadings before the trial court, and it is at page 330 of the paper book, SLP paper book.
There's one fact I would like to bring to your lordship's notice. After the judgment, my lords, of the High Court against me, so far as the government of India is concerned, it issues an order saying hand over possession pursuant to the cancellation of the lease.
The termination order of 2004.
It is a communication, my lord, saying that
Unauthorized occupant, the lease period has already expired in 2016. Last 10
Yes.
years you are occupying
But
the land as
suppose-
an unauthorized occupant now.
suppose a decision regarding cancellation was in my favor. Because the delay of the court, my lords, is there, which cannot be taken into account. Suppose, my lord, the cancellation had been set aside, am I not entitled? Because under the rule, under the contract, the right of renewal is there. I have to read the renewal clause.
Mr. Venugopal, you are absolutely right.
Yes.
The suit being decreed in your favor, holding the termination on breach, being invalid, you had the right to seek renewal.
Yes.
It's a contingent renewal that you have complied with the terms and you are seeking renewal.
Yes.
One issue of the contingency is subject matter of the earlier suit.
Yes.
The second you have already invoked. In these circumstances, it was incumbent on your client to seek an amendment of the prayers in the suit as soon as the cause of action arose upon termination in 2016. Having not done that, you cannot take advantage of your failure to say that the suit should continue to subsist and thereby enliven and give right to a stale claim.
Lord, may I just seek to answer
And
your
sir, what is
may I just
stated in
seek to answer
paragraph
your
20
lordship's
of the High
objection?
Court judgment?
Lord, may I just seek to answer your lordship's objection? No, the question is not whether whether I have sought amendment. The question is whether I sought renewal of the lease in accordance with the terms of the lease. And that application for renewal is pending. Therefore, why should I ask for amendment? It's for government to decide as to whether renewal will be granted or not granted. Therefore, my lord, my respectful submission to your lordships is this. So far as this city civil court is concerned, on the date when this judgment was delivered, it was still pending as to whether the cancellation was valid or not. And if it was held in my favor, even before, this was argued specifically, that the challenge is pending. And nowhere is it dealt with. Should not the High Court have at least dealt with the argument raised that the challenge to the termination is pending, still pending, before the city civil court? And therefore, that should be decided first. With nowhere, I do not find any reference to this. And therefore, my respectful submission to your lordship is.
We are not, this is a question of public property, how it should be dealt with.
May I just, with the permission of my learned senior friend, madam.
Yes, madam.
I just want to show one page, madam.
Please go ahead.
Page 305, the Union of India said, please consider his renewal application. Kindly just see that, madam. Page 305.
Even if Union of India
Yes.
grant, I think these are the matters where the court must know how to interfere. It's a question of public property at a prime location. Some affluent person has taken the land and he should be allowed to continue. What about the lesser mortal people
With respect,
in the country?
with all due respect, my lord,
Huh?
they
What
want to
100
now,
years you have enjoyed this property.
my lord, I want to show only 2 pages if your lordship permit me.
Now, going by constitutional philosophy, why a court should rescue this kind of hobnobbing or collusive arrangement between you and central government?
But there is no collusiveness, my lord, at all. I have not been informed that my application has been rejected at any time.
Because
Only
you
in court, my lord.
119-17, understandable, you took a lease. 99-year lease expiring. The government of India, some officially definitely colluding with you.
With all due respect, my lord, if your lordship see, my lord, what has happened here, if your lordship, allow me 2 pages only, my lord, 305 is a letter written by the Union of India to the Salt Commissioner that they have received the renewal application and this should be examined at page 305.
Yes, yes.
That's one thing. Second, my lord, is if your lordships come to page 540, my lord, the Union of India itself filed a case against the state of Maharashtra when they wanted to take over the land. And my lord, the statement made by the Advocate General is,
Understandable that state, the property, whether it vests in union or in this.
no, my lord, it rests in the Union, my lord, that is not an issue. They can only allot, they can take an allotment from the Union of India. They can't, my lord, it does not vest in the state. But 541, my lord, the statement recorded by the learned Advocate General at page 541 may kindly be seen. On 17th March 2025, learned Advocate General submitted that the central government has already taken a decision to allot the land in question to the state government. The state government has initiated the proceeding seeking change of user of the land, which is pending before the central government. It is at this point of time, my lord, I came to know that my application for renewal is not being considered any further. Therefore, my lord, I filed the amendment application. My lord put it, my lord, that why after 2016, why in 2025? I'm only answering.
We are not commenting on the application for renewal, whatever, if you have any remedy, any right, you can avail that. We are not
The suit stand dismissed today. Kindly appreciate.
Suit was against the termination of lease.
Yes, sir. So therefore,
Termination lease expired in 2016. Suit had been.
no, therefore the application was filed that the suit should be dismissed as infructuous. We contested the matter. The trial court said, no, it cannot be dismissed at this stage. Issues have been framed. We will try the suit and decide the matter. Now, in that, my lord, they went to the High Court under 115, as my lord senior friend pointed out. And the High Court, my lord, is exercising section 151 power.
Right, so High Court has at least rescued a public property.
Lord, it's not, Lord, the question is, Lord, that, yeah, and what do they do, my lord, ultimately? At 687, they try to take possession of the land because of the termination of 2004, not because of efflux of time. Kindly see page 687.
Somebody must be colluding with you.
No.
What is the question of termination now? The lease has expired in 2016.
I'm sorry, my lord. Kindly just read that letter at 657.
By a flux of time.
It doesn't say that by a flux of time. Kindly read, my lord, with me one more page, not
no, that will clarify.
This is written here, my lord. If I may just read 3 lines. At 657, my lord. This is 18th March 2026, one day after the judgment of the impugned judgment of the High Court of 17th March. What this is being said, my lord, that the High Court has allowed the petition for dismissal of the suit, number so and so. That is the lessee of Arthur will against lease termination order dated 211, whereby leases of the land under such and such have been terminated. Despite that, you have not handed over vacant and peaceful possession. Therefore, hand over peaceful possession. So therefore, it is on the. Sorry, I'm so sorry. No, I'm sorry. No, I'm sorry.
Take over the position.
I'm very sorry.
No, please.
No. That's not fair on my part. Lord, so therefore, what I am saying is that the ground being used to take possession is the ground, my lord, that the termination suit has been dismissed. Therefore, you hand me the possession, not that by a flux of time, because the prayer before the High Court was that by a flux of time.
That we can clarify to that.
So therefore, my lord, it is not that clarification will go against us further, my lord. If your lordship just now observed that if you have any other cause of action, you can pursue. If your lordship say that, my lord, then not even that liberty which your lordship is just now observing. My lord.
It may not be for us to say whatever remedy.
No,
we have
I'm just saying, my lord, your lordship observed just now, therefore I'm
since
very
the
sorry.
99 years lease, since the 99 years lease, which commenced on 15th October 1917, expired during pendency of the civil suit, on
15/10/2016.
15
15/10/2016.
15/10/2016, the subject lease shall be deemed to have the lease period in the instant case shall be deemed to have expired, not deemed, the subject lease shall be deemed to have been terminated by a flux of time on expiry of the 99 years lease period. In other words, the order dated 2nd November 2004 terminating the lease became infructuous on account of ad interim injunction granted by the civil court, which continued to operate till the lease period
It
itself.
was granted by the High Court, my lord. Earlier, the matter was filed in the High Court, then the jurisdiction changed and the matter went to the trial court.
Granted by
So therefore, it was granted by the High Court initially in 2005.
which remained operative till the lease period itself came to
It was operative.
expire.
It was operative till the, my lord, High Court
Disposal of.
impugned order.
Some order was passed.
When it was operative till
Till the impugned judgment was passed by the High Court on 17th March
26.
2026. Disposal.
My lord, just one line, my lord. The High Court itself shows in paragraph 24 that if I have a right of renewal, my lord, I can still pursue that remedy. Lordship may not close that, my lord, with all due respect.
Whatever.
No, so therefore, my lord, once your lordship put it like this, my lord, then
It is clarified that the petition shall be at liberty to avail the remedy as by the
As per law, your lordship.
as per law. 24, my lord.
As per law.
24 says so.
in accordance with.
As per law, your lordship.
Yes, para 24 in accordance with law
Suit,
is bound to be.
fresh constituted suit, provided you have the limitation.
Exactly, my lord. In accordance with law, High Court cannot extend limits.
If your lordship, my lord, permit me, my lord, to file the suit, my lord.
Why should we?
I'm saying,
Why should we?
my lord is observed.
But he wants this delay to be condoned by a judicial order.
No, don't delay will be.
Mr. Venugopal
We
has,
come back
when
after.
Mr. Venugopal has argued on holding over in view of the fact that the expiration does not amount to an automatic handing over of possession and cause of action not arising till the refusal of the renewal. So these issues will be decided in the subsequent suit. Why should we do it now?
That is the crux of the issue.
Yes.
Lordship,
We come after.
lordship,
Right.
Yes, item 54.
Yes, my lord. This is, my lord, the whole process was in contraventions of the Act itself, 1951 Act. My lord, lordships have several times have laid down the law. The power of superintendence, that doesn't, my lord, take away the legislative power. Now, only the superintendent's power will be working in unoccupied field. And here, my lord, kindly see one after another statutory provisions. I will show to your lordships. Kindly see, my lord, first page 85, first similar page 85. Of course, this is 95 Act, but the language I wish to show to you, lordships. My lord. Page 85, kindly come to page 85.
This is not something that first time has happened, or that it has happened only in one state. It happens everywhere in.
No, that's the reason, my lord, the challenge is here. That the Election Commission has to act in terms of the statutory provisions. They cannot act, my lord, in contravention. I do not know, my lord, other states, but the state consultation is needed. I do not know whether in, my lord, even previously, up to 2024, even the by-election, consultation with the state government has happened in West Bengal. But now the consultation with the state government has not been happened. Kindly similar first, my lord, this section, my lord, 13C, kindly see 13C, 13. The assistant letter registration of the Election Commission may appoint one or more persons as assistant letter registration officers to assist in electoral registration. That is the only power has been given to the Election Commission.
The High Court has examined threadbare everything.
No, High Court has not given the answer to the legal questions at all. No, High Court has not given the answer to the legal. Threadbare arguments have been made, but threadbare, this the answer has not been given. Kindly come to page 106. Kindly see, first, section 21. Returning officers for every constituency, for every election, to fill a seat or seats in this Council of States, for every election by the members of the Legislative Assembly of a state, to fill a seat or seats in the legislature of the Election Commission, in consultation with the government of the state, designated or nominated returning officer who shall be an officer of the government of local authority. Now, my lord, kindly come to, just I showed to your lordship, page 218. Kindly come to page 218. 218.
Yes.
See, my lord, Election Commission of India to the Chief Electoral Officer. Yeah, I am directed to refer your emails dated 19 on the subject above and to state that the Commission has agreed to your proposal. That is the CO's proposal, not the state government's, my lord, the recommendation. Even your lordships kindly see Article 324 sub-Article 6. Request has to be made to the governor. That has also not been done. Every state, I don't know, my lord, earlier up to 2025 by-election, it was done. Now, my lord, kindly come to page 104 again. Kindly see, my lord, section 28A. 28A. The returning officer, assistant returning officer, presiding officer.
The officers who have been transferred or posted, they are all of West Bengal cadre. It's not that people have been brought from outside. They were all your serving officers.
No, my serving officer, but state government serving officer. The High Court has mixed up the issues. My lord, High Court has mixed up. The point is, my lord, I appear against the state, for this state. High Court has mixed up the issues with me, my lord. That is the problem.
They are serving in the state of
identification problem.
Whether they occupy A post or B post, how does it matter? What prejudice, what serious kind of a...
My lord, a mandatory provision of the statute is violated. Question is not the prejudice or no prejudice.
You know the word consultation.
My lord, now your lordship is observing this, can I say one thing, subject to your lordship's permission? What has happened? You have changed the SP, you have changed the DG, you have changed everyone. State government has, on its assessment, has made it. After the changing, what has happened? Kaliachok incident has happened. Question is not that. The question is that the competent officers, there may be so many officers, all are not equal competent. Why, how the Kaliachok incident has happened? How the other places law and order problems are there? Since your lordship has raised the question, Lord, otherwise I would not have said this.
It all depends upon when you give the opportunity to perform. Then only one can evaluate whether they are competent officer, incompetent officer. In order to ensure that there is some element of some fairness, objectivity in performance of duty, this exercise has undertaken. Now the officers are in place. Your state is going for election in a couple of days. Even assuming that what you say.
Well, may I just, I can understand. I will not be an impracticable person. I can understand. May I make one request to us? Just one request. I am not saying that you stay, interfere. I have raised substantive questions. Very substantive. Read section 20 of the Act. This is question. I have raised substantive questions. If your lords, can your lordships can decide it after that also. I read section. I just showed to your lordships one very important question. I think this question has not been raised there. Kindly see read section 20 of the RPR.
Instead of deciding academically, then something which we can take up at the initial stage itself. We will decide in an appropriate case. We will keep the question of law open because we understand this kind of situation may arise. But as of now, the point is only that consultation is not concurrence.
Maybe, consultation is not consultation is not concurrence. It doesn't mean that consultation will not be taken place. Your lordships have taken the governor's case of the university.
Yes.
Your lordships have seen that consultation may not be in concurrence, but consultation, absence of consultation is not required. Can I show one section?
Sir, in the context of appointment of judges has been interpreted differently only so that it draw color from the basic principle of independence of judiciary. That's why consultation in appointment with Chief Justice of the High Court, Chief Justice of India, that's a different meaning. In the rest of the statutes or wherever this word consultation, you know very well, who knows better than you, that interpretation given by court.
Just I give to consultation is not concurrence. I can understand. I can understand my fate, Millard.
No,
Millard, consultation is not concurrence. I can understand, but consultation will not. The consultation will not be taken place. Millard, that is also not the law.
We will keep the question of law open so that you may be right tomorrow. It may create. Suppose in a case, Election Commission of India and block bring officer from outside. Assuming.
Yes.
Not a single state cadre officer is allowed to perform. There may be an extreme situation where court's interference might be.
Millard, I can understand extreme situation. But 1,100 officers overnight have been transferred under what assessment? 1,000. Millard, this is the first time in West Bengal. Millard, a chief secretary has been transferred. And your lordships have recorded your lordship's order. The day she appeared before the lordship's court. And your lordships have recorded an order. There is a fight between the central government and state, election commission and the state. And who was representing the state? The chief secretary. And first time in India, the chief secretary has been transferred the day the notification has been made. Because she was opposing all the suggestions. Is it a fault? Is it a ground to transfer? DG, my lord, your lordships constituted a committee. That DG, chief secretary, they will represent. when they are represented before the honorable.
Unfortunately, this is the misfortune of the country, that the very object of creation of all India services is getting frustrated. Officers are also only for the sake of plum posting and for all personal benefits. They go and they surrender completely only to secure position,
Only two.
only to secure transfer postings on better places. So this is how the impression sometimes is created in the mind of the general public, that we will not be able to get a fair opportunity, will not be able to get a fair treatment from them. This unfortunate impression
The,
leads to
the problem is, to post is someone in sensitive post. Why your lordships are transferred? Someone as district judge, someone as the labor tribunal. That's an assessment.
the worst example for your state in this, and your state means that why it so happened that we have to use our judicial officers even for that.
No.
That again shows the trust deficit.
No. If the,
And trust deficit both sides, not you. They have no trust in the officers of the state government. State had no trust in the officers which were sought to be brought from outside. And therefore we had no choice.
then in that case, this is the first time in the history in India, this has been brought by this election commission. One has to accept it. Up to this, not a single chief election commissioner has raised this question. First time he is raising this question. Does it not create a doubt? Anybody has done it. Anyone has done it in this way. First time one chief election commission, my lord, I am not talking about the power. Kindly, my lord, existence of power and applicability of the powers are completely two different things. If it is two different things, how the election commissioner, chief election commissioner is doing that? All the chief election commissioner was what? I want to show your lordships one section, then your lordships, whatever your lordships will decide. I hope that this is one of the important questions I have raised. Kindly read, my lord, section 20 of the 51 Act. That is, my lord, your lordships kindly come to page 104. I will not take your lordships much time. Kindly, my lord, kindly read. That is the questions I have raised. Possibly this was not raised earlier. And kindly come to 20B. May I read it? The election commission may nominate an observer who shall be an officer of government to watch the conduct of elections or elections in a constituency or a group of constituencies and to perform such other aspects. I am not on. An officer of government. What is the government? Government is state government or state governments. Can you make an observer of this? So long 20B exists. What is the Article 12 of what I have about said? Article 12. State means state unique. How there can be an observer from one state to Kerala state? Or Kerala state to West Bengal?
No, observers from outside the state is not a new practice.
Not a new practice. I am flagging the issue now. Maybe there is a practice is going on, but if the practice is contrary to the statute.
Practice must be as old as maybe 25, 30, 40 years old.
No, this is after not even Mr. Session. After that, 2004, 2005, it has been started. Yes, 20 years.
Maybe 20
years.
Yes,
20 years. Not even Mr. Session. Now, the question is, sometimes one has to raise we are in the court to raise an issue. But the practice is...
Mr. Kalyan, let us not keep West Bengal election in mind. An observer from outside the state is always ideal.
I am not saying it is not good, but until Parliament changes the law, we go by the law.
See,
Parliament changes the law. Can we read something? Can we read something which is beyond the law?
Problem is that today, in a particular factual background, if you say no, Election Commission of India will not do it because there is no parliamentary legislation authorizing him to do so. But look at the consequences. In a case where election commission, forget about allegations, we are only talking about an as a constitutional institution. Tomorrow, if Election Commission of India is required to take some drastic measures to ensure a fair and free election, and if you start questioning them that since there is no parliamentary act authorizing you to take certain action.
Well, the question is coming.
My brother, I think this is what exactly I was looking for also. The statute also describe it differently. So in the case of returning officer, officer of the state is a requirement and that has to be complied with. In the case of observer, it should be only an government servant.
That's right. But I am reading to the provisions. If your lordship read down in other way, that will be the law. It will be binding. But up till today, the law is different. Well, may I just one make submission? Why? Why this time alone, so many questions are raised? Earlier, the questions have not been raised. I am busy in the election. Now I am busy in the court. Why this time? Only this time.
Mr. Bandyopadhyay, I should open my mouth here. West Bengal elections have been a field day for electoral litigation.
Not in this way.
From 1978-80.
No, that is up to 81. That was the electoral rule. That is a preparation of the electoral rule. No, that is now SIR.
Look, it may come in different facets, but the ultimate allegations and the challenges in Lokhikanto Sen.
That is 68.
82.
82.
Lokhikanto Sen.
82 in Supreme Court. Right. Yes. Jyoti Basu.
Then Mr. Ajit Paja was one of the petitioners in Lokhikanto Sen, where he said in his constituency there was en masse inclusion of names, and 5 electors of Shampukur Assembly constituency filed the writ petition before the then later on becoming Chief Justice of India, Justice Shobhoshaji Mukherjee.
Yes. That time, your lordship, that was my first matter in my profession.
Travels to Supreme Court
Yes.
becomes one of the authoritative pronouncements.
1981. That was my first matter. That was my first matter in my profession. My profession started with the election petition. Hasanujam, that is the 1981 Supreme Court report.
Yes,
Order was passed in 81. Judgment was delivered in 84.
That was a minority judgment. Justice Baharul Islam said.
No, full judgment came out in 1984.
Reasons were given. Because Justice Baharul Islam deferred.
That is the full judgment came in 1984. Anyway, that is a wholesale. I am not. These are the on.
No, you see, we said,
We'll keep the question of
on
law
whether we
open.
keep the issue open because your consultation point has some substance with regard to returning officer.
Rather we
But
will say
observer may be outside the state because there the border is government and not government of the state.
Yes. And kindly read 324 sub-article 6.
That we see.
Then when you are exercising power under article 324(1), why you will not obey the 324 sub-article 6? And whenever the governor exercises power, my lord knows that on the basis of the Council of Ministers' advice.
No, not in 324.
Though the petitioner.
324(6).
324.
We will say like this, though the petitioner has raised some substantial question of law, which might require consideration. However, keeping in view the stage and the polling scheduled to take place in the state, we are not inclined to entertain the special petition. The question of law is kept up. That will take care of.
Well, that was I was expecting, not much. Very honestly speaking. How the High Court has rejected me after hearing a shortcut process was taken, that is not also, kindly do not mind, that was not acceptable to me. I am arguing matters to 2 days. If you want to dismiss on technical ground, dismiss it within 5 minutes. I have no difficulties. But you have allowed me to argue for 2 days. I argued. Thereafter, a shortcut process has been undertaken by the High Court to dismiss my case without deciding when questions of law have been decided. This is required to be decided. I hope I made myself very clear to your lords. I'm deeply obliged to your lords, and I will try do not disturb to your lords up to 29th April.
Yes, my lord. Here in this case, my lord, only thing is the lordship. Now, election is again coming 2027 February. And now we are almost 9 months left, my lord, to be decided our case, my lord. And then 93 times, my lord, we have already completed, my lord. My lord, in this case, my lord. So my representation is also there. Prefer to the Honorable Chief Justice, my lord.
The petitioner has filed an election petition number 9/2022 before the Manipur High Court, challenging the election of number 2. Manipur Legislative Assembly held on 28th February 2022. Since the next election is due in February 2027, we request the High Court to dispose of the petitioner's election petition as early as possible.
Yes, my lord. But within some time frame, my lord. Some time frame, my lord.
Fix a time.
No, otherwise, because after fixing, because there are only 3 judges, my lord, left, my lord, here, my lord, at the same time.
In your High Court, now should I tell you, I keep also a reasonable track. 37 election petitions in your High Court.
Yes, 36 already, my lord.
37.
Including
all the 3 judges are taking a single bench. Chief Justice himself is also sitting single bench.
Yes, my lord.
Unfortunately, there are 2 vacancies in your High Court, so let's see that when
because in case if it is because even it can be
as of now,
it may be fill up soon, my lord, either from transfer or from the bench, whatever may be the cases, my lord. That will be sooner is better, my lord. Because put that also filling up. Yes, my lord. Deeply obliged, man.
Yes, item 56.
Yes, my lord, Chief Justice. Very recently, very rightly said, my lord, at least the army men should not be forced to fight in the court. We are, my lord, 50 retired personnel before the lordships. The discrimination is this, my lord. There are various verticals of the ministry, like in finance ministry, there is a bank, there is a LIC, there is the income tax office. So retired personnel who join the bank are getting the undue hardship class and pay fixation. The retired person who joined the LIC also getting, but we who are working in the income tax office just.
So for that, because these are service benefits, how should we should entertain 32 writ petitions?
My lord, I am saying this. I understand, my lord, and that's why I have written at page 3, my lord. Why this is the maintainable, my lord? Just see my page 3. I have given 10 reasons, my lord, page 3, 4, and 5. Why, my lord, this can be maintained? We are, my lord, 50 before the lordships. 500, at least 500 more are waiting.
Don't invite a dismissal order. Better if you want to represent to authorities or anything you want to go. Otherwise, we can't entertain.
My lord, we have submitted to our representation to the respective authorities.
You pursue those representations. If they are not deciding, go to go to this CAT.
My lord, I understand, my lord. What will happen, my lord? It will be a multiplicity. We are in a 54, 55, 56, etc. My lord.
Whatever it is.
Till the time the, my lord, CAT will decide, we will be retired. And at least finally, my lord, it will be decided by this honorable court.
What it's a money claim.
If I, my lord, just
people are dying, people don't have source of livelihood. People at least are in re-employment. You served in army, again you are in the second employment.
Lordships are right, my lord. But
you are far better place as compared to millions of people in the country.
My lord, in L. Chandra-Kumar, lordship says that CAT is the substitute of the high courts. But CAT is not substitute of this honorable court. Why I am saying, my lord? This one petition will decide at least 500 cases, outcome of this petition, my lord. Otherwise, there will be flood of, there will be flood in the CAT also, my lord. Every individual will go there. And my lord, after retirement, some of have to go to the Calcutta, some of will be shipped to Bangalore.
Nowadays, it's not required to go anywhere. You can appear online and assist the courts.
Then my humble request is this, my lord. Please keep it. Just let I will serve the copies to the, my lord, ministries, respective ministries, my lord. Let this petition be considered the representation and decide this 50 people had page number, my lord. Just I am giving the.
Again, problem is that because of the order bias, then people will start coming. If you will not file, someone will come in contempt, the other will come directly telling the order. It creates a problem. This is not a good precedent for this court.
In some cases, lordships have directed the respondents to consider the petition as a representation, my lord. It is in the, my lord, many, my lord, 50 before lordships and at least 500 are waiting. They may be join this online and watching what is the outcome. So my humble request is, my lord, keeping in view this army persons, my lord, let this petition be as a representation and be decided within 3 months or lordships what deems fit, my lord.
We are not inclined to entertain this petition. The article of the Constitution. The petitions, IPSO advised, may submit their comprehensive presentations to the authorities concerned, and if their grievances are not effectively addressed, liberty is granted to uphold the central administrative tribunal.
My lord, representation within 3 months, my lord. 3 months is reasonable time, my lord.
We cannot fix because these are different ministries, different authorities. So we have granted liberty that you can approve it.
As soon as possible, my lord, if lordship may right.
Like all that we will say.
As soon as possible, my lord.
Item 57.
May please, my lord. While hearing the criminal appeal diary number 32456 of 2025, my lord, in that case, if these orders be a part of the order, there was a reference in the order of conviction and sentencing about these orders, so that your lordship, while issuing the notice and while granting the entry order, examined the issue, and your lordship said that in case I would have been there, I would have said that when the first contempt was completed, 2006, I was quite a young and now I am a senior citizen. But you lordship, presently, can see how the lawlessness is prevailing, my lord. please see for page 47 for a minute, my lord. Please see 47. Blood, this matter was released by the another such by the bench of such. Last line, blood. There are 3 more content applications. Very never. Malay Lucknow made the chief just senior judge.
Meanwhile, further posting in contempt application claim number 309 of 276 shall be instituted.
Another connected matter. Lord, all the 5 cases have been connected.
No, that's all. That's fine.
Not the senior judge. Senior judge is performing duties of chief justice, which is not permissible.
Yes, item 58.
The same incident, my lord, against the same incident, my lord, 2 FIRs, different FIRs was registered. My lord, in one FIR, closure report has been filed stating that no cognizable offense has been committed by the petitioner herein, my lord. My lord, the another FIR which has been lodged at PS Dargah, petitioner once approached before the High Court, my lord, but due to some threat he could not pursue his case. My lord, petitioner is a handicapped person and not able to frequently visit to Rajasthan, my lord. At this point of time, my lord, in FIR number 50 that is pending in PS Dargah.
This is very because the Rajasthan High.
It's your petition for non-prosecution.
Yes, my lord. That's why, my lord, there was some threat and he could not pursue his case properly, my lord.
Could again go to the High Court and could explain this.
My lord, what I am requesting, my lord, I am ready to join the investigation at PS Dargah. Meanwhile, the warrant has been issued against me, and all offences are less than 7 years. If my lord will permit me, I will also approach to the High Court, my lord, and I will also join the investigation. If my lord may dispose of my petition by giving opportunity to join the investigation, I'm just requesting.
You are saying what?
I'm just requesting, my lord, if my lord may permit me, I am ready to join investigation. All offences are less than 7 years. So if I am ready to cooperate with the investigation also. If my lord may give me permission, I will also withdraw an approach to the High Court, and within 15 days I will join the investigation if no course of action will be taken against me. Just
stay your arrest for a couple of weeks.
Yes, my lord.
So that meanwhile you can approach the High Court.
My lord, if also possible, I will join the investigation also.
So having heard non-constitutional
much objection.
While we are not inclined to entertain this petition under Article 32 of the Constitution, however, having regard to the fact that the petitioner is a woman.
Not a woman, my lord. He's a handicapped, he's a male person.
And having regard to the fact that the petitioner is willing to, that the petitioner wishes to approach the High Court for quashing of the FIR. And for that purpose, we cannot proceed further due to apprehension of arrest. Committee directed that the petition shall not be arrested in FIR number 15/2024 for a period of 6 weeks, so that meanwhile he may approach the jurisdiction of High Court for appropriate relief.
Much objection. Much objection.
Yes, sir. Just have the impugned order, Millards. Actually, the High Court has admitted my petition.
Yes.
The High Court admits the petition. Sorry, so sorry. Lordships have seen the impugned order.
You can seek, what can we do? Because either you seek early hearing or you follow the advice of the High Court. High Court is right in saying that you can file a private complaint.
Can I just indicate what are the facts, minutes? We give a detailed complaint to the EOW and the
So far,
CBI.
your story is really, who is going to convince themselves that
Because what is important is, since because there is the borrower and the public sector banks are involved, gave a complaint to the CBI. What
on the asking of the public sector bank,
yes,
you claim to have given 500 crore rupees, 600 crore rupees.
right, absolutely. And because it was
You have so much overflowing money that the oral assurance of the institutions you are.
Because it is kept in a separate account. Because what happens is that it is kept in a separate account. This was a shipping company. It needed what is called fuel, otherwise it won't work.
Mr. Gaurav,
yes,
you also know very well, you mean your clients
yes,
know
yes,
very well,
yes.
that's case of pure civil contractual failure of contractual obligations, if at all.
Plus that's
prosecution will not be possible. But you want arm twisting.
Well, actually, I only want the, so sorry. Because I only want the CBI to look into it. Just see CBI's response, Millers, at page 40, Millers. Just have a look at one document. The CBI, actually EOW forwards it to the CBI. Now CBI says, Millers, we are not even conducting an inquiry into the matter. So we went to the High Court saying, please ask the CBI. If on the inquiry they say no offense is made out, matter is over. But the CBI says, I don't even want to look into it and conduct an inquiry into the matter. Please.
Agarwal, how do you expect this order at the ad interim stage?
No, but so therefore, because
admission notice, and you can take out.
Because admit, because the High Court it remain pending for next 10 to 15 years. Because Bombay High Court, that's a difficulty.
How can interim direction be issued to register the FIR?
No, not to register. That's why I said, please have a look at the prayer, Millers. Page 94. I amended the prayer. Just have a look at the prayer. I just had two documents in mind and nothing. Please have a look at the prayer at page 94, Millers. Just have a look at the prayer, Millers. Lordships have prayer, page 93, Millers. Please have a look at that. Just have a look at the prayer. Because it was amended pursuant to counter was called, rejoinder has been filed. Now just have a look. Thereby directing the office of R3 to submit, Lordships have 94 top minutes. I'm just not reading the first three lines. It is not, sorry, so sorry, my Lord the Chief Justice.
These are all pressure tactics, nothing more.
Well, the only prayer was for the CBI to say you have received a complaint and then you have forwarded it back to the SBI Vigilance.
Passed in January, you can approach the High Court again. What is the problem?
Because my learned colleagues tell me it will take 10 years for the matter to be heard. That's all the difficulties. High Court could have said either way decided the matter one way or the other. Because it was not some big question of law which arose for consideration. Pleadings are complete in the High Court.
An interlocutory order whereby the High Court has declined to grant interim relief. In our considered opinion, the petitioner may approach, in our considered opinion, the appropriate remedy for the petitioner would be to approach the High Court. High Court for out of turn hearing of the case.
Millers.
Especially keeping in view the nature of relief sought in the petition.
Grateful to Lordship.
With liberty of formation, the special education.
The Lordship will give me the liberty to approve. Lordships have just indicate the High Court may consider my application. That's all. One line if such an application is made with us.
Thank you.
Grateful to Lordship. Obliged to Lordship.
60 is that matter regarding, my Lord, inheritance rights of Muslim women. Of course, my lord, I agree that ideally there should be a uniform civil law. There should be. But the problem is that in the absence of that, there are today, my lord, almost 100 million Muslim women who are being discriminated with as a result of this Sharia application law, section 2 of the Sharia application law of 1937. It says that the Sharia law will apply regarding interstate succession. And unfortunately, my lord, under the Sharia law, Muslim women are discriminated against. They receive half or sometimes even less of what their male counterparts receive. And therefore, we are saying that this is discriminatory. This is violative of Article 14. And if your lordship strikes this down, then we are saying that your lordship can do either of, last time your lordship's concern was that there will be a vacuum. What will happen? And what we have suggested is that either your lordship may say that the Indian Succession Act, where it says that it will not apply to Mohammedans, your lordship may read that down.
They cannot legislate.
That is also amount to legislating.
No, no, my lord, it's a reading down for a specific purpose.
There is no reading down.
And your lordship has already held.
Reading down is
No, I know.
a higher bar being brought down. You were just asking us to delete a particular provision from.
We are saying that in order, because my lord, what is the foundation of this challenge? The foundation is Article 14. We are saying that this provision fill up that vacuum in many ways. One way is what your lordship said in this tribal Chhattisgarh Ramcharan case, where your lordship said that, well, in the vacuum, you will apply equity, the principles of equity.
Just good conscience.
Yes, equity and good conscience. The other way is to say, well, whatever law is applied, it can't be discriminatory against women. The men and women have to be.
In that case,
yes,
the legislature was silent. So unoccupied field,
yes,
we observe justice, equity, good conscience. Here, the Sharia law exists.
So that we are challenging. We are saying that is discriminatory.
Sharia law should be held ultra vires.
So for the first time, my lord, your lordship will be examining that. The question is very simple. Prima facie, my lord, on the face of it, it is discriminatory to say that women will get half or even less than what their counterpart males will get by way of inheritance. Now, the question is whether this is an essential religious practice protected by Section 25. And in so many cases, my lord, your lordship has held, for example, in triple talaq, your lordship held that is not an essential religious practice. This certainly, my lord, is a purely civil matter. It can't be an essential religious practice protected under Article 25 of the Constitution.
That may not be a religious practice. That too.
Therefore,
testamentary is also in Section 2, Section 3. Testamentary is not essential religious practice because the act itself counts it out. It's an optional.
the prayers at page 80, the prayers. First is, my lord, first prayer is declare Section 2 of the Sharia Application Act 1937 insofar as it governs interstate succession, is unconstitutional and violative of 14, 15, 21, etc. Second is, declare that the rules of interstate and testamentary succession under Muslim personal law do not constitute essential religious practices under Article 25 and are subject to constitutional scrutiny. To my mind, my lord, it's an obvious proposition that this is a purely civil issue. The testament or the rights, inheritance rights of Muslim women certainly is not an essential.
Mr. Bhushan, someone will argue
Yes.
that it's a question of personal law.
Yes. It may be a question of personal law, but it's not an essential religious practice protected under Article 25. And in the absence of that, my lord, it is certainly subject to Article 14. If it is subject to Article 14, then, my lord, it's prima facie, ex facie discriminatory. And if it is discriminatory, my lord, it needs to be struck down. Now the question is, what will happen? Whether there will be a vacuum, what will happen? If your lordship strikes down that and says that no, Sharia law will not apply, it can't be discriminatory, then one non-discriminatory law which can be applied is the Indian Succession Act, which is completely agnostic towards male and females. So, although, my lord, that law was meant to be applied to Christians, Parsis, etc.
But there probably section 2 or expressly says it won't apply to.
Yes, yes, it does. It does say it will not apply to Muslims,
So
Hindus.
Unless that provision is struck down.
Yes, so we are effectively saying, my lord, that your lordship can strike it down in this also, because Hindu succession law is codified by the Hindu Succession Act. Only the Muslim succession law is not codified. That's the only law which is not codified, and it is subject. And if your lordship reads Mullah, the rules of succession under the Sharia law are so complicated that it is impossible even for lawyers to discern what is the succession practice under the Sharia law, etc. Therefore, at least this much needs to be done, that it can't be discriminatory between males and females.
Either way, our criticism will be that we want to either legislate or
ideally, I agree with you.
Amend the existing law.
I have always maintained, my lord, and I have always told my Muslim friends also that don't oppose uniform civil code. Many of them, my lord, oppose uniform civil code because the fear is that in the name of a uniform civil code, the Hindu civil code will be imposed on them. This is the fear. So I have always said that civil law should be uniform for all, across all religions. Civil law should only.
Code is a constitutional declaration. Uniform civil code has nothing to do with any religion particularly. It's a constitutional ambition.
Yes, yes. It's a constitutional ambition for good reason. Because the civil law should be uniform in a country, irrespective of religion.
In fact, in a way, if you look at the personal law of marriage,
yes,
the Special Marriage Act is one of the steps towards uniformity in matrimony.
Yes, yes, yes.
That you have an option.
And unfortunately,
to opt out from your personal law.
Yes.
And solemnize a marriage,
yes,
as well as the rights of paternity and custody, etc.
Yes, correct, my lord.
Under the Special Marriage Act.
Correct. Unfortunately.
And now also with the Juvenile Justice Act.
Yes.
Permitting adoption.
Yes.
So you make inroads into the personal law domain. But Mr. Bhushan, these have been legislative interdicts.
Yes.
They are legislative exercises. Will it be appropriate for the court to delve into these?
So that legislation, my lord, the
freedom
section.
of religion is a part of the fundamental rights.
No, freedom of religion is. But, my lord, the question is, if a religious practice is inherently discriminatory or against equity, good conscience, etc., which are a lot of
things. Public order, morality.
etc. Therefore,
it's called foul of neither of these three standards.
Yes, so there, my lord, even if it's a religious practice, it has to be struck down. Because the constitution, once the constitution comes, it does not permit any practice to be discriminatory, inherently discriminatory, unless, my lord, your lordship elevates it to the principle of an essential religious practice protected under Article 25. Until that happens, my lord, and I submit that certainly inheritance is not an essential religious practice protected under Article 25. Your lordship has held for so many things that these are not essential religious practices. For example, even praying in a mosque, your lordship has held is not an essential religious practice.
That we are examining.
That's all right. There are several other cases which are similar or allied, which are pending before this court. For example, my lord, there is in this Safia PM versus Union of India, the question which is pending before, there are at least 3 cases which are allied, which are pending before this court. Naushad versus Union of India, Khurram Sunat Society versus Union of India. These are all allied issues, not exactly identical, but allied issues. And my lord, in Shabnam Hashmi, your lordship held that even the rights of adoption, and in Mary Roy also your lordship held that the Christian women in Travancore, there was a Travancore Act which discriminated against Christian women, and your lordship held that that act has to give way to the Indian Succession Act, and the Indian Succession Act, which is agnostic between men and women, will have to apply. So this is certainly, my lord, an important legal question which needs to be examined by this court, and it's arising actually directly for the first time before this court, though there are allied issues which are pending before this court. In Safia PM, my lord, which is pending before this court, the issue is whether a person born Muslim but no longer a believer can be compelled to be governed by the Muslim personal law in matters of inheritance and succession. In Naushad, my lord, the question is whether a Muslim individual can opt to be governed by the Indian Succession Act instead of Muslim personal law. These are all pending before this court. Quran Sunnat Society versus Union of India, the question is application of Muslim personal law in matters of inheritance and succession. Similar question, my lord. So these are pending before this court, but this matter needs to be examined by this.
Which matter is pending on the inheritance?
This is
Quran Sunnat Society.
Quran Sunnat Society versus Union of India.
Does not ask whether inheritance is an essential religious practice.
This was, no, that's all right, filed in 2016, but it is still pending. The other one, my lord, whether a Muslim individual can opt to be governed by the Indian Succession Act 1925 instead of Muslim personal law, this is also pending. This is Naushad versus notice was issued on 17th April last year, about a year ago.
Mr. Bhushan, at least instead of giving it, I mean, of course, public interest, PIL it can be because public interest element is there.
Yeah.
But always ideal in such like matters, some aggrieved person is also there.
No, in fact, my lord, the advocate on record is a Muslim woman, but man, and the petitioner, the second petitioner is a Muslim woman.
There is a foundation. Huh?
But I have actually, my lord, I saw after the last hearing of this case where your lordship heard the unamended petition, there was an avalanche of people who had issued
their effort. These two girls, I was just looking at who are the persons and.
Yes, yes. So this young lady, my lord, who has drafted.
We will take up it after 2-3 weeks. Meanwhile, just find out some who are the.
No, any number. Actually, my lord, there was a statement issued by a very large number of people supporting this petition.
We've attached that as annexure.
They will persuade someone to.
They
had all supported this petition. Formally issued a statement.
Issued a press statement that we have attached as annexure. They officially issued a press statement.
Oh, must be. There must be.
Many people have issued one. Groups called Indian Muslim for Secular Democracy, the Bhartiya Muslim Mahila.
Irrespective of the religion or region, you will find people are suffering from different kind of local issues, religious issues, state issues. There are victims always in a system. So if A formally on record comes forward.
No, that we can do. There is no, last time also I had said, my lord, I can bring any number of petitioners, Muslim women who can be petitioners in this case. If your lordship sees that statement, इसमें लगा हुआ है?
On facts, if someone makes out that this is how they will.
Annex 1. Letter that has been attached. लगा?
Yeah, Annexure 1. Even the media, yes, Annexure 1.
Annexure 1 of the petition, my lord, is a letter which has been signed by so many Muslim women, men and women both. Page 89. This is the list of signatories. And my lord, the statement is on the earlier at page 86. It's a long press statement by Indian Muslims for Secular Democracy.
And the Bharatiya Muslim Mahila.
And they say at the end, IMSD supports at page 88 at the bottom, supports the ongoing Supreme Court proceedings and calls for a resolution that guarantees equal inheritance rights for Muslim women across India. We advocate for a solution that addresses gender discrimination in all personal laws, ensuring that women from all communities are treated as equal citizens entitled to dignity and justice under the law. I was saying, Lord, that though the Special Marriage Act is a proper codified law, in the Hindu Marriage Act, it says, unless custom otherwise permits. For example, marrying your first cousin. It is not permitted in North India, it is permitted in South India, in most places.
And the court has never clarified that.
So even testamentary succession, you can't give more than 1/3. There is a big problem.
Your Lordship, if I could make a small point. Section 3 of the Shariat Application Act 1937 makes testamentary succession voluntary or an opt-in scheme in which you have to file a declaration to opt in. However, since there are no rules how to file a declaration, it is operated as a residuary law right now. Making 172 million Muslims, which is according to the 2011 census, completely incapable of willing away their own self-acquired property according to their own will. Testamentary succession is not an essential religious practice as it is in the act itself. If it was an essential religious practice, it would be part of the mandatory part. But it is not part of the mandatory part. It is an optional. The legislature itself carved it out. Yet, because of residual application, it is being applied, and every Muslim who has self-acquired property is being held to this 1/3 restriction without any proper statutory backing of the situation. This is also a very important question that needs to be considered.
Anyway, my lord, this is certainly a very important constitutional issue which needs to be considered and decided by this court.
Much obliged, Your Lordship.
Just give us the number of that 2016 matter.
These are the three cases. The last one is the one which your lordship is referring to.
Should be also present. And meanwhile, us.
Much obliged, Your Lordship.
Yes, this one.
Let's find out some actual sufferers.
Yes.
Because for the purpose of tomorrow, the issue of 25 will also arise. The other issue will arise at least.
No, we will certainly get, my lord, a large number of Muslim women who have been denied equal rights and therefore who are aggrieved by this. So.
Denial is at least not a dispute.
Yes.
Denial will definitely there.
Yes.
If your lordships permit me, your lordship, I can pass over a compilation of news reports of many women who have been denied. These are recent news reports from from Pulitzer institution, Outlook, etc. For lordships. I will also add this as amendment in the.
She has done a lot of work in this case.
Add them
Very.
as interveners or parties to this.
Will do, your lordship, will do.
So
All
that
right.
it does not appear to be a group of persons challenging personal faith,
Fair
but
enough,
a sort of reformation from within the faith.
Deeply understood.
We will do that. We will.
Much obliged, your lordships.
I understand, my lord, this is a sensitive matter.
Yes.
This will raise a lot of hackles and sensitivities.
Want to have the exercise of reformation, because what we are doing is catalyzing a reformation
Yes.
that should come from within the sect itself.
Ideally, yes. It should. The problem there is, as I was saying, my lord, even Hindu law is not uniform. Customs are different. So therefore, if they want to make a uniform civil code, they will have to go one way or the other. For example, whether you can marry your first cousin or not. There will have to be a uniform law. It can't be left to custom if there is a uniform law.
The answer is there in the constitution.
Pardon, my lord?
Answer is there in the constitution. The thing is, how much the society is ready to
Ideally. So, my lord, what needs to be done is that for drafting the Uniform Civil Code, I have always maintained for drafting the Uniform Civil Code, my lord, one must incorporate the most liberal elements which are non-discriminatory from the various civil codes, etc. of different religions.
Idea is to develop a scientific, rational, humanistic temper as engrafted in the fundamental duties. But Mr. Bhushan,
absolutely, my lord.
Appreciate.
Unfortunately, we are going the opposite direction.
I don't know where we are acutely conscious of our limitations as a constitutional entity to preserve constitution. But is it within the scope, ambit, and ability of judiciary to make social reforms?
So it's not that, my lord. It is within the scope, ambit of the judiciary to strike down discriminatory provisions. That is certainly.
Discriminatory laws.
Discriminatory laws or discriminatory provisions in various laws. So that is certainly within the remit of the judiciary. But of course, ideally, as I said, ideally there should be a uniform civil code, but it should not become, as my lord, Muslims fear. Muslims fear is that it will become de facto the Hindu civil code, which will be imposed, though the Hindu civil code is also not uniform. It is not uniform because it is dependent upon custom. So even that is not uniform. So ideally, it should be combining the most liberal elements, which are non-discriminatory, and I am obliged.
Permission to add petitioners or
Go ahead. We will add the petitioner. Your lordship may permit us to add.
As intervener, they can.
Yes, yes.
Thank you, your lordship. Much obliged.
You know, this is a 28 years old boy. He's done that. His name has come in the disclosure. All the main accused are on bail already. And lordship may kindly see. In fact, the High Court also granted in interim initially, and then said serious. What, Mills, if the others have been left in, he's not even named. He was not present. They found.
Cyber criminal.
No, that's the only reason that cyber. But all of them are within 2 months. They're out. I have not been named. My name has come. He knows me.
You are the one who was.
Milo, that's not correct. Lordship, may kindly have page 61 for a minute. It's their own case that this man who has given the disclosure statement owns. Milo, may have page 61. Mahesh Chandra claims himself to be the owner of. He worked with me sometime in 2017.
With Rahul, he started the business.
Milo, I know that's his statement, that's his disclosure, but he's himself saying. Milo, he's himself saying that he's the owner.
That name is not there in the FIR. These are the things.
No, I'm not saying, I'm not.
Offensive, offensive.
Because if it was
Yes,
something very serious,
I was not present, that's why I'm not named.
Because I'm not,
Cybercrime.
not a, it's not a, I have, all of them have been already now let off on bail for within 2 months. When the High Court granted me interim, I have always cooperated also. It's not that he's just 28 years old.
Their cooperatively, I don't know anything. No, I don't know. My mobile is lost.
But my lord may kindly see, all others have been granted now. My lord may kindly see the orders. My lord, all of them, the main accused has been granted within 2 months. Because all the page 43, my lord may have, my lord, the main accused has also been let off. And they found, my lord, they found nothing. There is no complaint that we have cheated any.
I think his co-accused we have already dismissed.
My lord, co-accused have been granted bail regular. All of them have been granted. Lords,
Vinod Kumar is co-accused.
No, Vinod Kumar, is Vinod Kumar a co-accused? Because in the disclosure statement, if it's come, I don't know. There are 3 I have annexed orders. Mahesh Kumar, Krishan Lal and Kokdi Cham. They have all been granted. My lord may see their orders. My lord, their names are also there similar.
Let him surrender and seek regular bail.
My lord, the only thing is this, if there is still date nothing against him, my full cooperation.
Vinod Kumar was his co-accused.
Vinod Kumar is Vinod Kumar a co-accused? No, they'll check. If he's there, then I will obviously.
Identical grounds. Absolutely identical grounds.
Is it correct? Check, Vinod. If it is, Vinod, then I will. Is it correct?
Vinod Kumar.
No, Vinod Kumar may have been on the spot. I am not.
Same learned judge denied bail. To him also anticipatory bail. Vinod Kumar, same FIR, everything.
Same FIR. FIR he must have been named. If there is a Vinod Kumar, he might have been named. Let me just check.
No, he's not named. He said he was not named. Vinod Kumar also, and in disclosure statement, Narendra Kumar revealed his name. Same Narendra Kumar has revealed your name.
No, my case Mahesh Kumar has done it. Same Mahesh Kumar. Then I can only say now that if that, I don't know what stage.
We can't pass a different.
If my lords have said, then I can't. Obviously, I will not. But only thing is, he has also.